morning, Sarah. Good morning, lady. Have a seat. Thank you. Mr. Monda, BCT.
Yes, Your Honor, in the matter, Miss Timon and Miss Gashanja.
Miss
Gashanja. Yes, Gashanja.
All right. Defense team, I will take you last. Yeah, for the victim. Defense team.
Good morning, lady.
Good morning.
My name is Malova. I'm appearing alongside my learned friend, Mr. Nick Leder. Miss Margaret Obuya. Mr. Kane Mingo. Mr. Daniel Lungu. And Mr. Michael Amalemba for the accused person.
Van Straten.
Yes, but you see that's not English. Spell for us.
Yes.
Yes.
The name said is S.
No, that one I got it in the Bible. The second one.
The second is Van, V-A-N.
B.
V.
V-A-N.
V for vowel.
Yes.
Then Straten is S-T-R-A-T-E-N.
Yes. T-E-N.
Yes.
Stratton and?
And Roy Van Straten, the same.
Right. Any other?
His counsel here.
Yes, another advocate?
Yes.
Together with?
Good morning.
Good morning.
I appear for Dr.
The administrator. You are nodding. Council stand up.
Yes, my
Yes. Administrator for?
the victim's estate.
Yes.
Cohen.
Right. That's fine. Any other person who wants to be put on record? None. Okay. The matter of opposing bail.
Yes, yes.
I want you to demonstrate compelling reasons, period. But this is how we're going to do it. If I let you, you'll get run away. I want you to give me points.
Yes.
This is number one, the reason why we are opposing bail. First reason, the law is already established. It's
Very
out
true.
there.
Very
The
true.
Constitution says it's a constitutional right. So give me the compelling reason, point, and then case law. Very, very briefly. Now, before we proceed, counsel, the defense team, who is the lead counsel? I want that on record. Are you all going to make submissions like the first day? No. How many of you are going to submit? Who is the lead counsel? How many of you are submitting?
My name is Malova. I'm the lead counselor.
Either of you can make very, very brief submissions to back up, but really, really brief. Do not repeat. The last time I allowed you to speak, all of you repeated the same pitch.
Most of likely.
Only 2 years that I have. Okay. Now, that goes to the prosecution team. Who is the lead counsel?
I'll be the lead counsel.
Yes.
I'll make my submissions in less than 15
15 minutes. All right.
Okay. So, who under the witness protection program? The second is likelihood of interferences with witnesses.
Yes.
And the third, flight risk. I will deal with the first issue, and my colleague Ms. Ogweno will deal with the next 2 issues: interference with witnesses and flight risk.
You are dealing with the witnesses under the witness protection.
Yes, yes. Witnesses under the witness protection. Yes, before I begin, Your Honor, we have an affidavit sworn by the Assistant Superintendent of Police, Maxwell Otieno, dated the 29th of January 2025. It was filed in court and duly served upon my learned friends.
We've received the same money.
Do you have our copy? If not, since someone to print, continue.
Yes, Your Honor. I will deal with the issue of protected witnesses, which is found at paragraph 7 of that affidavit. These witnesses, Your Honor, who are under protection was because of intimidation and interference from the accused person. My colleague will delve into depth the evidence we have attached in the affidavit to demonstrate this. My submission, Your Honor, is that at this stage, it will be prejudicial to the prosecution case to have the accused person released before these two protected witnesses testify. The prosecution is ready and willing to avail these two witnesses to testify as soon as possible, and thereafter the accused person can renew her application for bail. Your Honor, I rely on the decision of Republic versus Doyo, Galgalo, and 3 others. Which is a reported decision by your brother Justice F. Diconyo, delivered on the 12th of February 2019. He was confronted with a similar scenario. I draw your attention to paragraph 5, that decision. Paragraph 5 on page 2 of 4. Where the accused persons had been initially released on bond and the DPP subsequently terminated the case. Thereafter, the charge of murder was preferred against the accused persons. And some of the witnesses had been placed in the witness protection program. So one of the compelling reasons was interferences and intimidation of witnesses. And the judge at paragraph 14 states as follows. I note that the prosecution has informed the court that some witnesses are already under the witness protection scheme and has intimated to court that it will make secure, it to make appropriate application for the court to adopt such safe and appropriate procedures and lawful method, avoid any interference with security of witnesses and prejudice to the witness, the witness protection scheme, and for the sake of probity of these proceedings, it is not appropriate to release the accused on bail for now. Those are our submissions. I'm aware that this case shall be heard on the 25th of February 2019, and upon taking of the vulnerable witness testimony, the issue of bond will be revisited on the 25th. So our submission, Your Honor, is that at this stage, it will be prejudicial. Two, in any event, because they are protected witnesses, these proceedings must take place in camera. In the circumstances, Your Honor, taking...
You are now submitting?
Yes, I'm just saying in the circumstances, Your Honor.
Are the witnesses going to, would you like your witnesses to testify in camera?
Yes, the protected witnesses, Your Honor, the two. Because, Your Honor, they cannot proceed in the manner we are proceeding today. They are protected. That is the essence of these protective measures. So at the appropriate moment, we will be beseeching this court that they take their testimony in camera, so as not to prejudice.
Just a clarification.
Yes.
Camera can still be under this, you see the witness protection
Yes,
box?
yes, box. I'm saying
We
that
can
they
place them
cannot
in the
just...
witness protection
Yes.
box without voice distortion?
With-
Or do you want voice distortion?
No, there must
Just-
be every protective measures, Your Honor. That's what we'll be seeking.
Depends on what you saw.
Both identification
And,
and voice distortion.
voice distortion.
Yes.
Okay.
Because they can also be recognition by voice, I do agree. So we'll be seeking both identification and voice
Have you made
distortion.
the application to any High Court judge to have the measures put in place? Have you already made that application?
No, Your Honor, at this juncture,
Not yet.
we have not yet made the application
Okay.
because it is now that you're taking over those proceedings.
Okay.
But we are just informing you that already the two witnesses are in the program. So at the appropriate moment, once this court gives the necessary directions, then we'll be able to make those appropriate applications. Including the use of pseudonyms insofar as their testimony.
Yeah.
So, Your Honor, we urge you to be persuaded by the decision of Brother Justice Gikomyo and allow the two protected witnesses to testify before we can proceed with the bail application. I now hand it over to my colleague, Ms. Ogweno, to proceed.
She's a fast speaker. Just slow it down. Yeah.
I'll try to be. And the second ground is on witness interference. And this is demonstrated in paragraph 8. Paragraph 10. And also
Statements
where the witnesses itemized.
pass over. Have you passed over court the statement? The two statements as 2 and 3, yes.
They were already marked, so maybe
Yeah, okay.
yes.
Proceed.
So our next
We further wish to highlight to this honorable court on behalf of the victim's estate that the accused is actively interfering with potential evidence that would be furnished to this honorable court by dint of her living and residing in the home which is owned by the victim and in which my lady is part of the public record that the victim's body was found.
Is it a crime scene that should be coming from the state? Is that home a crime scene? Why was it not secured? How did she find herself there? Respond. Continue.
Yes,
Continue
my lady.
responding. I'm
Yes,
just
my
pointing out because
Yes.
you're telling me it's a crime scene. How is she within the crime scene? How did she end up in the premises? Was it secured? Was it open? Who gave the order for access to the crime scene? Right, proceed.
And my lady, indeed, we were shocked to learn on behalf of the victim's estate during the course of administering the victim's estate that the accused had somehow made her way back to the site in which the victim's body was found. And indeed, my lady, it would be a grave miscarriage of justice if the accused was somehow allowed to go back to the very scene in which material evidence and testimony will emanate from. It is our humble request, in addition to the submissions given by my honorable learned friends, that the victim is barred from accessing the property pending the outcome.
Property on where? This
The
specific-
property, the victim's
The-
property, in this case, the house on Farasi Lane.
Yes, also be specific, because maybe he has other properties, but let's be specific to
Yes,
the issue of the scene of crime.
yes, my lady.
Yes.
The house on Farasi Lane, which was the scene in which the victim's body was retrieved. Those are humble submissions.
We take the evidence of the two protected witnesses, then we can go on to discuss issues. That is all.
The right is not absolute. Must be demonstrated. The prosecution has filed an affidavit by Officer Maxwell Otieno. It's a 19-paragraph affidavit with exhibits attached thereto. With this, they say this affidavit contains the compelling reasons why the accused person should not be admitted to bail. But it is important that this court understands that this is not the first time that these charges are before you, my lady. The accused person was charged on 12 September 2019 with the same offense, similar facts. And she entered a plea of not guilty. 12 September 2019. An application for bail was made by the accused person on 16th September 2019. And in opposition to that bail application, the prosecution presented an affidavit by the same Mr. Officer Maxwell Otieno, a 52-paragraph affidavit dated 18th September 2019. My lady, this matter was placed before your learned sister, before your sister. Justice Mutuku. I've attached the ruling of that bail application. And in her wisdom, the judge summarized the compelling reasons.
Refer me to the paragraphs.
Yes, I will find it.
And just number. Don't read.
That's fine, my lady.
Yeah, but
It was not
paragraph.
properly numbered.
In her ruling, yes. Which page? Refer me to the page.
I will find it to page 5.
Page 5 from paragraph.
From the page 4, determination from the last paragraph. The learned judge highlighted the compelling reasons
Yeah.
picked up from the affidavit and from the prosecution of Maxwell Otieno. My lady, the first one, the learned judge Maxwell, and the submissions by the prosecution is that there are two principal grounds that they want you to have a look at and deny the accused person bail. The first one is interference with witnesses. My lady, we filed a replying affidavit in opposition. It's signed by the accused person on 31st January 2015. She's made, she's responded to each and every allegation raised in the affidavit, and my lady, I know when you retire, you'll have a look at them.
Mm-hmm.
But you've been referred to a statement is on a balance of probability. In the event that this statement was and the material were with the ODPP, is it not probable that they ought to have investigated this and point to the accused person? Would such a statement be severe enough to deny an accused person fundamental right to bail in the circumstances? My lady, the submission before you, Father, on the interference of witnesses is that these witnesses are under the Witness Protection Program. My lady, the Witness Protection Program is designed, it's actually from an act of parliament, and is designed to protect witnesses in trials who are deemed to be vulnerable. By the laws, the state sets aside resources to ensure this program is operational. My lady, the last exhibit attached to the affidavit of Maxwell Otieno the last exhibit attached the affidavit of Maxwell Otieno in opposition to the bail application. Is a letter by the DCI addressed to the Director of Witness Protection Agency. This letter is dated 19th September 2019. My lady, by this letter, the prosecution confirmed that they had already admitted four witnesses to the witness protection program. And in the ruling, of the learned sister of 11th October 2019 with respect to this witness protection, the court made the following finding. May just allow me to read it for emphasis. This is a paragraph 4, at page 4 of the ruling, interference with witnesses. The learned judge held, paragraph 4 of the ruling of the learned sister, Justice Mutuku. On interference with witnesses, my lady, just allow me to read for emphasis purposes. This issue has been raised by both the prosecution and the siblings of the deceased. The accused, through her legal counsel, has maintained that up to this moment the defense does not have a list of witnesses, and therefore the accused or her counsel do not know who the witnesses for the prosecution will be. This is a fact that is not denied. Indeed, during these proceedings, the prosecution sought more time to place some of the witnesses in the witness protection program. On 3rd October 2019, the prosecution was seeking 5 working days to finalize with the application, to finalize with the Witness Protection Agency on the protection of its witnesses and to redact the statements of these witnesses. The court declined this application, noting that the prosecution has had all the time from 26 September 2019, when this bail application was supposed to be heard, to sort out the issues of witness protection. It is noteworthy that from 3rd October 2019 to today, the 5 working days have elapsed, and it is my belief that the prosecution are finalized in protecting its witnesses. My lady, today is 3rd February 2025, 6 years down the line. The court found 5 working days then was enough. 6 years is more than enough. My lady, no evidence has been presented before you right now to suggest that the accused has tried, attempted.
So you're saying no evidence has been presented to the court to suggest that?
That the accused person
Yeah.
has attempted to circumvent the witness protection program, that has been placed by way of acts of parliament. Regulations are there, laws are there to ensure that this system works. No evidence has been presented before you right now to show that the accused person has the resources, means to circumvent this program. My lady, the second ground that the prosecution this morning relies on to urge the court to deny the plaintiff, the accused person bail, is the issue of the fixed abode. My lady, the accused person was admitted to bail in the initial case, criminal case number 60 of 2019. In August 2019, around August 2019, the prosecution, I'll get the right date, the prosecution filed a nolle prosequi terminating the proceedings in criminal case, High Court criminal case number 60 of 2019, And at that point, the accused person was discharged. All the conditions of bail were vacated. The bail amount that she had deposited of 2 million shillings was returned to her. The fixed abode that was preserved as a crime scene was free now for the accused person to access. She has been living in this home since 2022.
When were the proceedings terminated?
In November 2022. The prosecutions themselves terminated the proceedings. They never made any application then to continue preserving this fixed abode. My lady, the accused person has been residing in these premises. She was the wife of the deceased person. My lady, this was their matrimonial home. It is not true that this was the house of the deceased. It was a matrimonial home. The prosecution had all the time to assess and value the properties from 2019 to date. They did not see the need of preserving this home if they thought they would come back and file fresh charges. Of course, that house is terminated. It's contaminated. My apologies. There's nothing before you right now to urge you, my lady, to preserve this fixed abode that is fresh from what was presented in 2019. My lady, I wish to state that most of these arguments that indicated, the testimonies, the redacted statements, they were all made in 2019. They were they've been before this court in the inquest. There's an inquest that was on this matter. There's nothing new. Since 2019 to date, no evidence has been presented that the accused person has tried to interfere with witnesses, to interfere with the investigations, to tamper with the crime scene. We pray, my lady, that you admit the accused person to bail. This is not the first time that she was admitted to bail. When she was admitted to bail, she complied with all the conditions. She never missed court. No evidence has been presented to show that she attempted to run away from the jurisdiction of this court. She's not a flight risk. We urge, my lady, that you admit the accused person to bail. That's all, my lady.
Two points. One, and this is in relation to my learned senior's submissions, and they refer to the very ruling he submitted before this court. That's number 16 of 2019 at Meru. And I draw this court's attention to paragraph 3A, where, unlike this particular instance,
Page?
first page, paragraph 3,
Page 1,
paragraph 3A,
yes.
unlike this specific matter, the persons here were politically active, with great influence in the community, and therefore immediately likely to interfere with witnesses. Zara is not any of those things. She's been out on bail and then free for the last 6 years, with no interference with these witnesses. And two, you will note in paragraph 1 of counsel's own.
We agree that should you find something missing in the proceedings, you will not break the court. You can see the court is writing. The court can only be able to capture what it can. So you need to slow down a little bit. She's not a licensed. She has been out for 6 years. Yes.
Not a person of influence in the community, private individual in good standing, and therefore quite unlikely suddenly, after 6 years, to now start interfering with his businesses. In paragraph 1 of Council's authority, the court is clear about the standard of proof. In a being bond application. It states, and I quote, "This is a high standard which I believe draws from the constitutional threshold on limitation of rights set out in Article 24 of the Constitution. Therefore, the evidence should be rousing and one that brings conviction to the court to deny bail. I submit none of us here are roused or convicted to deny our client bail. My lady, I urge this court to consider the accused person also as a victim. To consider the accused person as a victim. Sir is presumed innocent until it is proven otherwise. When this matter was first in court in 2019, she was remanded in custody for well over 2 months. Today, she's been in custody almost 2 weeks. By the prosecution's own admission, she was denied access to a matrimonial home for 4 years. Despite the fact that the prosecution had already collected over 32 DNA evidence samples from the matrimonial home in 2019. She was still denied access to our home. Now, 6 years later, we are here to discuss keeping her in custody, despite the fact that she is innocent. Finally, we urge this court to uphold the protections envisioned in our Constitution and submit our client to reasonable bail for the terms. That is
it. Now we'll get back to yourselves, delivering.
This stage, we are not shutting out the accused person from revisiting this application. We are saying that allow the 2 witnesses who are under protection to testify, then renew your application. We are already unwilling, even next week, to avail these witnesses to testify, because in our view, it will be highly prejudicial should the accused person be released.
It's your submission.
Yes.
The 2 witnesses, once they testify, the accused person should be released on bond or an application for bail relief should be made. Which is which?
My submission is this.
Yes.
Let the 2 witnesses
Yes.
testify,
Yes.
and then we can revisit the issue of bail. And that's why I would like you to be persuaded by the decision of your brother, Justice Cohen. And that's what he did. At this stage, he denied the accused person's bail, but fast-tracked the process for the witnesses to testify, and thereafter ordered that the bail application issue be revisited. So that's what we are asking you. My learned friend made reference to the statement. We invite the court to read the statement in whole, and particularly at page 5. That is annexed MO2. Read it in whole. In our humble view, it demonstrates that the accused person interfered. And that's why, Rona, we we are apprehensive that should she be released at this stage on bail, then the prosecution will be jeopardized. You the accused person on bail pending trial at this stage. Lastly, Your Honor, there's an issue my learned friend raised about the accused being kicked out of the house. I just refer you to the ruling by your sister, Justice Mutuku. She is the one who directed that she should not return back to that house because it's a sin. So it is not that we kicked her out. It was a directive from the court. And that directive, Your Honor, at the very end,
So do not think I want you to respond at this juncture. Yes.
I know it's irregular, but perhaps I can make one comment.
You can, you may.
Learned Senior has made a lot to do about how they are ready and willing, but the reality is there's going to be some trials in advance. We're going to receive the evidence. We might want to have our own experts look at it. So even if they are willing to avail the witnesses next week, in reality, I don't see us starting the trial next week.
That is why we always say the wheels of justice around like, you know, the train that used to go to Kisumu in 1942, I didn't see it. Justice does not fly like the Concorde. That's the most unfortunate thing about justice. And that is why that train never got a single accident. But the Concorde has crashed. Even the Boeing has crashed because of the speed. The wheels of justice run very, very slowly. That's the most unfortunate. I have never known why. Maybe then when we meet again, you will let me know why. To avoid probably accidents, those kind of Kisumu, and so I'm not going to give you a ruling on the spot. Unfortunately, this week, I'm working at Kahawa. Law courts handling the receipt case. This ruling can only be delivered. Give me the diary. So kindly allow me to do my own. So the whole of this week I'll be at Kahawa. Unfortunately, it can only be on the 18th or 19th of February when I cannot render that ruling. I am really, really, really very, very busy, so busy because of other equally important cases. I will have to deliver the ruling on, choose the date. I'll give you 18th, 19th, 20th and 21st. Choose one of the dates convenient to yourselves.
18 is available. It's convenient to me.
Remember, I am only squeezing you into my appeals course list. Murder cases are handled on Wednesdays and Thursdays.
Oh, that's on Wednesday.
So she'll have to be remanded until 18th of February. Reason is that we do our rulings and judgments at home, and I already have so many others that I have to do over this weekend and the next weekend. So I'll only be handling yours on the next weekend. Yeah.
Most of that.
Okay. Have a good day, everyone.